Good afternoon. Today I will be discussing an overview of a retainer fee agreement made between attorney Barry Forrester and client Valerie Victim. Please note that this is only an academic exercise created by a student and is not a real retainer agreement or a real case. Now, with this retainer agreement, it is documented that the law firm has agreed to represent you, Ms. Valerie Victim, in the matter of assault and battery, and the fact that the opposing party, Tammy Tortfeasor, bestowed upon you. This retainer agreement is non-negotiable and is put in place to prevent any confusion or misunderstandings during our attorney-client relationship. It's noted in Rule 1.5 of the Tennessee Rules of Professional Conduct 10, and is strongly encouraged that all agreements are in writing. Now, as we go along with this, if you have any questions, please feel free to ask. With this agreement, you agree to pay all expenses incurred, including but not limited to court costs, witness fees, mediator fees, if a party agrees to mediate. Mediators are those who serve the general public. They're more of like third parties in which they assist disputes between parties by guiding them into an agreement. Arbitrators are the same, except they can be independent persons. You may pay for mileage for any travel outside of Nashville. In the case of a witness, for an example, that should testify in court but lives across the state, let's say in California. As previously agreed on, I will represent on the basis of a 30% contingency fee, meaning it is subject to change on the basis of the winning of the case. If the case is won, I will receive 30% of the settlement after reimbursement of expenses and costs, as referred to in Rule 1.5c. A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraph D or other law. A contingent fee agreement shall be in writing, signed by the client, and shall state the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal. Litigation and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after the contingent fee is calculated. So for an example, if all of the expenses and costs amount to, let's say, $5,000, and your case settles for, why don't we say, $11,000, I would receive in the amount, as your attorney, $1,800. And you, Miss Valerie Victim, as the client, will receive in an amount of $4,200 for final settlement. Now again, it is set up to where your reimbursement of expenses and costs come out of your settlement first, and then the contingency fee of my 30% comes out last. Then the rest is all in your hands. Any questions so far? Great. Along with that, you also, as the client, agree to payment of my attorney service fees. My rate, as shown here, amounts to $95 per hour. Meaning, if I spend, for an example, 2 hours on preparation of documents, that could cost you roughly around $190. Now, this hourly rate applies to all services shown, but not limited to in this paragraph. Now, as your attorney, I am responsible for legal services reasonably necessary as stated. This client and attorney-based relationship. Therefore, as your attorney, I will not make any moves without consulting with you first. Now, as I stated, I cannot make any promises or guarantees regarding the end result of your case, meaning I won't tell you in the front end that you will win, but I can promise and guarantee that I will do my best in trying to help you win this case. I will provide copies for your own personal file of pleadings, documents, and other information. Please be sure to bring all necessary items when we meet here in the firm. I also have a file for your case in which I will bring as well, but this action is just to put into place to make sure we are both engaged within the case. All right? Now, all that I ask of you as the client is to be open and honest with me at all times. I cannot fully help you to the extent possible if I don't have all details. The more information it is, the better. I also ask that you do, as agreed in this agreement, to pay all costs and expenses as well as attorney service fees as mentioned in the beginning. Failure to care for your responsibilities gives me the right to withdraw as your attorney, which is stated here in your agreement. Now, please, please, please do all that you can to make sure that you fulfill all responsibilities. It is so very important. Okay? Now, as your attorney with the law firm, it is my lawful duty to protect all confidentiality. This may include directly meaning obvious items or information, and indirectly meaning small, frivolous items or information. So any information that is really serious, or even just the slightest information as your name. This provision continues even after termination of this agreement and or after your file is destroyed after the 2 years. Now, if you decide to authorize and agree to more representation besides my law firm, that is totally fine. But you must consider the division of fee that is paid to both myself and anyone else from another law firm. It's brought out in Rule 1.5E 1 through 3. A division of a fee between lawyers who are not in the same firm may be made only if the division is in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. The client agrees to the arrangement and the agreement is confirmed in writing, and the total fee is reasonable. So, this agreement, of course, is in accordance with the Tennessee laws. And by signing this agreement, you acknowledge that you have read and understood and accepted all terms. So, do you have any questions? Alrighty. You may sign and let's win your case.